Joining us now, Slate senior writer and co-host of the Amicus podcast, Mark Joseph Stern. GLAAD Law Senior Director of Civil Rights and Legal Strategies, Mary Buonato. She was one of the attorneys who argued before the Supreme Court in the Obergefell case. And former Assistant U.S. Attorney, visiting law professor at American University Law School, and author of the Little Law School Substack, Kim Wehle. All right, so I think we're going to have some differing opinions on this, which is going to be a good thing for the conversation. I'm going to start with you, Mark. Do you believe that this court will hear Kim Davis's case?
No, I do not believe for a second that the court will hear this zombie case. I think the court will overwhelmingly reject this petition. There may be one or two dissents from Thomas or Alito because they want to reiterate their opposition to marriage equality as a precedent. But I think the odds are exceedingly unlikely that the full court takes it up, in part because what Davis is really trying to do here is get out from under the $100,000 in damages that she owes to those two men in the video at the top of the hour to whom she denied a marriage license. Her attack on Obergefell is almost tacked on as an afterthought in this petition. And I think the justices will read this as more of a cynical effort by her lawyers to get more attention to the case and perhaps more fundraising dollars than a good faith legal effort to have the court revisit a landmark precedent.
All right. OK. Kim, do you agree with that?
Well, I agree that it's a landmark precedent that shouldn't be disturbed. But given what the court has been doing with established constitutional law, expressed in the Constitution, as well as, of course, what happened to Roe versus Wade and overturning Dobbs, I think it's possible the court will take this. And the court adopts now this history and tradition test for determining whether a constitutional right exists if it's not expressed in the Constitution. There's nothing anywhere in the Constitution about marriage. There's nothing about dignity, and gay marriage wasn't introduced legally until the early 2000s in the country of the Netherlands. So as much as I think it would be egregious to take this case up, I think if the court takes it up, it would be very easy under existing precedent in the last few years for this majority to justify sending marriage back to the states. It's not making marriages null and void, gay marriages. It would be doing what it did with abortion and say, listen, it's not in the Constitution. You gotta argue for it before the state legislatures. And moving forward, it's up to the states to make this determination. I think that's a very viable option with this particular Supreme Court majority.
So I think it's worth reminding everybody what that would mean, what it could look like for those who hold those marriage licenses. But I want to ask a question first of you, Mary, and this is of Justice Clarence Thomas's agreeing opinion, majority opinion on the overturning of Roe v. Wade. He said that they should use that, as Kim was saying, as precedent to look again at Obergefell. When you heard him argue that, and then you see this Kim Davis case, do you get nervous?
I am vigilant. I mean, you don't argue a case like that and ever let it go. But I would say that this is not a great case for the court to take. And she's been to the Sixth Circuit Court of Appeals 3 times, and they've turned her away each time, in part because she took the law into her own hands. She not only refused to issue licenses to that couple, which she did 3 times, but also instructed her whole office to do the same. Taking the law into your own hands is far beyond the rights of any kind of religious liberty you may have. So this is not a great case for them. And I will say, when she first filed a case in Kentucky, she said she wasn't trying to overturn Obergefell. And that also just tells us a lot about why this is not a great case for the court to take. But that all aside, in the end with marriage, what we have is something that's just been great for couples, great for their kids, great for society, great for the economy. And there's no real problems that people can point to. I hear the point about the Dobbs opinion, but I would say that in Dobbs, the court did not address the equal protection issues. And by contrast, the idea of equality and equal access to government marriage licenses and all that marriage brings with it was central in Obergefell, along with the other kind of reasoning about the right to marry. And it was a very strong right to marry opinion. And frankly, we now know 10 years plus out about how right the court was and how it really has supported families and children. And we've been able to balance religious liberty and, the beliefs that people have along with marriage.
I'm wondering, Mark, if you can give us a little sense of how this argument might play out within the court, because you have that Thomas opinion, which I think made a lot of folks nervous in the moment, or at least set off some alarm bells. But you also have Samuel Alito. Just the other day, he was speaking at a conference, and he mentioned Obergefell. He mentioned the case, and he said, in commenting on it, I am not suggesting that the decision in that case should be overruled. Do you take Justice Alito at his word there?
No, not at all, in part because he has already suggested in an opinion that it should be overruled. I think that he caught himself and was trying to avoid a bad headline. I don't think there's any question that if this issue came to the Supreme Court for the very first time right now, the court would rule against marriage equality 6-3. That is not the question. It's whether marriage equality as a precedent is vulnerable at this court. And I completely hear what my co-panelists are saying, and I agree there is some threat for sure. Because these are not justices friendly to gay rights as a general matter. These are not justices who came up in a movement that supported LGBTQ equality, but these are political justices. They know that they have a certain amount of political capital that they can spend down in issuing decisions that the country doesn't like. They already spent a lot of it in Dobbs. And I just don't think that marriage equality is an animating thing for them, a principle that drives them to say, we have to do whatever we can to rid this from the law books. I think it's something they don't love, but it's something that they can live with, especially because when they don't touch marriage equality, then they get to say, look, we're not unsettling every precedent we dislike. We're playing it by the rules sometimes. And that, I think they believe, gives them more space and, again, more capital to go after those decisions that they really hate the most. So I think this is a matter of balance and calculation.
I think that's interesting, and that's not a terrible way to look at it. I wonder, as flawed as this case is, as Mary points out, and the way that it's already been ruled on by various districts, and maybe just the visual that it looks like she's trying to get this money back, I wonder if there's another case that you think, if there were to be another case, and I don't have one off the top of my head, could you see the Supreme Court taking something else on to try to challenge gay rights, Kim?
So, yeah, I mean, I agree with the comment that if they were to take this up, I think it's going to be overruled. And I think Mary's points are extremely well taken in terms of the framing of this in particular. It's not a big secret that on both sides of the political spectrum, lawyers poke around for plaintiffs that can produce a good case to take to the Supreme Court. But there are two additional factors here, Katie, that I think are even more problematic for gay marriage than even abortion. And one is the First Amendment, this right, the alleged right to discriminate on the basis of your religious beliefs. This is something this court in a series of cases has started to elevate over other core constitutional rights. And then the other element, which I don't think gets enough discussion nationally, in part because people don't understand the nuances of how the Supreme Court functions, is what this court has been doing, as I mentioned, with established precedent on the shadow docket, green lighting the sending of migrants to South Sudan where they could be tortured and killed, notwithstanding the due process clause, allowing DOJ to take Social Security information in violation of the Privacy Act, also on an emergency motion. I mean, this court has not been uncomfortable with the politics of some things that, appropriations clause, spending clause cases. From a constitutional standpoint, it's astonishing what this majority has been doing without full briefing, without an explanation, and people should just look at the dissenting justices' opinions. So this gives me great pause for gay marriage, frankly.
So, Mary, on that subject, and I'm not saying it's going to happen, but I do think it's worth looking ahead. Remind us what it would be like for a married couple to lose the right of that marriage in another state. Say if you're a New York couple and you want to travel to Kentucky and gay marriage is legal in New York but not legal in Kentucky. What does that mean?
Well, there would be a lot of questions if Obergefell were reversed, because there is a bipartisan law passed in 2022, the Respect for Marriage Act, that where Congress came together and said, if you were validly married in one state, you should be married in every state, and you should be treated as a married person in that state, regardless of what their law is, regardless of amendments they may have passed in, previous years before people understood what this would look like. So that is there to try to protect people. But certainly, if Obergefell is overturned, a marriage on that day will look a lot different from a marriage today. It will be, seen as a second-class marriage, and I think would invite people to mischief. But again, the Respect for Marriage Act is supposed to ward against that, and certainly there'll be litigation. But in the end, I don't think any of us want to go back to the patchwork that was so difficult for people to manage and businesses to manage before. And people want to be able to count on their family status, protecting them when they cross state lines, to see family, go to reunions, take care of an elderly mother, whatever it might be.
Yeah.
So we don't want to go there. On the religious piece, I want to say I appreciate your slide. And I think what it does is it points out a broader trend that our society is facing that people have not really been paying attention to. They see these religious liberty issues as one-offs, and they're not. And again, that's why I look at the Kim Davis case and just other issues as the court's trying to set up frameworks, at least on marriage, where both can coexist. We've seen some cases where the court gave an exemption to a wedding website designer or a baker to say you don't have to work with the same-sex couple in this instance. But those are not broad exemptions. They were really targeted to the individual.